Good afternoon, everyone. My name is Dina Blickstein. I'm a partner at the law firm of Haynes & Boone, specializing in intellectual property, including patent prosecution, post-grant proceedings, and artificial intelligence. Joining me today are Jeremy Albright, Ilya Barazesh, and Roshan Mansingani. Why don't you three introduce yourselves? Let's start with Jeremy.
Thanks, Dina. I'm Jeremy Albright. I'm a senior associate at Norton Rose Fulbright, and about half of my practice is in patent prosecution, with the other half in post-grant proceedings such as IPRs and also re-examinations, ex parte re-examinations.
Let's go to Ilya.
Hi, everyone. Thank you, Dina. My name is Eliar Barazesh. I'm a senior associate at Baker Botts in Austin, Texas. My practice focuses on patent prosecution and counseling, PTAB proceedings, post-grant proceedings as a whole, including re-exams as well, and patent litigation. Happy to be here and talk about IPRs.
And Roshan?
Hi, I'm Roshan Mansingani, and I am Assistant General Counsel at Unified Patents. We are a membership organization dedicated to improving patent quality, including through the use of patent office proceedings to invalidate overbroad patents.
Well, welcome, everyone. This is the third and final installment of Post-Grant Review Trials 3, Interplay with District Court Litigation. Before we get started, let's first thank our sponsors. We have Mood, an online dispensary, followed by Type to Learn, Sunburst Digital, maker of #1 typing software for kids, grades K through 12, and Max Asset, the restructuring and insolvency professionals. Now, one final housekeeping item, our standard disclaimer. This webinar is for informational purposes only. It's not considered to be a legal or financial advice of any kind. If you need legal advice, please contact your legal counsel or feel free to get in touch with any one of us. And with that, let's get started. Interplay with District Courts Litigation. So Roshan, let's start with you. For the PTAB trials, are they generally standalone proceedings or are they part of a bigger litigation picture?
So most trials filed at the Patent Trial and Appeal Board involve patents that are litigated in district court. Actually wrote an article about this, and we crunched the numbers, and basically about 90% of PTAB cases involve a patent being asserted in district court litigation. That leaves the 10%. And why else would you file these? There are times where you are out of court negotiating with a patent owner, and you guys want some objective feedback from the patent office on the quality of the patents that you're considering licensing. So people use that. They'll go, again, that's not very often. And then also competitors will sometimes use the PTAB to take down patents that are important for the purposes of entering a market. So in the pharmaceutical industry, for example, we see this quite a bit. Generic drug makers trying to take down branded drug makers' patents in order to be able to have generics enter the market sooner.
Right. And at this point, there is no litigation whatsoever.
In some of those cases, that's right. Yeah. Yeah. So, but again, 90% of patents challenged at the Patent Trial and Appeal Board or the PTAB involve an underlying district court litigation stemming from a district court litigation.
All right. So let's focus on the other 90%. Right. Say there is a district court litigation. At which point would one file a petition, and what are the advantages and disadvantages? Jeremy? You're on mute.
Thanks, Dina. Well, to file a petition, that's going to first have to happen within 1 year of being served with a complaint alleging infringement of the patent. That's the 1-year bar. And so you're going to need to do it in that 1-year window, and ideally earlier in the window rather than later, because there are some discretionary reasons that a petition can be denied, even if it's otherwise meritorious. And one of those is if it's going to duplicate effort between proceedings. So if you file really late in the 1-year bar and you're in a very fast district court setting, it could be that the district court is going to progress far along by the time the PTAB reaches the final written decision. So within the 1-year bar, ideally earlier. And as far as advantages, I think it's my opinion that the PTAB is really the preferred forum for invalidity. And so you'd be seeking to invalidate the patent or patents that had been asserted against you. And I think it's a preferred forum for several reasons. One is that the standard is lower for invalidity at the PTAB. It's based on a preponderance of the evidence versus clear and convincing evidence at the district court. At the PTAB, it's going to be a panel of administrative law judges who are patent savvy, deciding the issues in the trial, who may be more likely to reach the right answer, particularly on highly technical subject matter. And I think that the odds of success at the PTAB are fairly high. I want to say it's 65 to 70% of petitions are instituted, meaning the PTAB takes them up and there's actually a PTAB trial on those petitions. And of instituted petitions, I believe it's like 5% of patents subject to those proceedings that make it through unscathed, meaning no claims held to be invalid. As far as disadvantages, I guess the one I would mention would be estoppel can be a disadvantage, because if you file for a PTAB trial, you seek to invalidate a claim in a patent. If it reaches final written decision, you're not going to be able to challenge that claim again later, whether in the district court or at the PTAB, on any ground that you could have raised in the trial. So it's sort of your one shot, is how I view it, to go after a claim. And that, I guess that can be a disadvantage. And really what it means is you should do the best job you possibly can with your petition and include all your evidence. And so hopefully that's not an issue.
Maybe I'll open it to everyone. What are some other disadvantages to filing a PTAB proceeding?
Yeah, so I can chime in. It's kind of going along the same lines, and I think what you're saying before the PTAB is going to have impacts as to what's going on at district court. So you just have to be careful that your positions are aligned, that you're not saying something that's completely opposite before the PTAB to what you're arguing in district court, because that would not look good, and you would be successful. So that's one kind of major just strategic call, that you just have to make sure your positions are aligned in both forums, and that goes a long way.
So Jeremy, earlier you mentioned that there is some overlap between the proceedings, especially in terms of invalidity positions. Is there any other types of overlap? Maybe Ilya?
Yeah, sure. So there can be, discovery-wise, discovery is a lot more limited in PTAB trials compared to in district court. But at the same time, in terms of claim construction, validity theories, infringement theories that kind of inform what invalidity will look like, there is overlap in those positions, and that was kind of what I was getting at when I was just mentioning earlier on the alignment. So really, you have to make sure that everything you're saying is part of a broader strategy, and you're not like shooting yourself in the foot. In terms of one specific facet of this, like prosecution history estoppel. So when you're in a PTAB proceeding as a patent owner, if you're making statements that disclaim a certain meaning of the patent claims before the PTAB, that will impact how the court will later interpret that claim. So you just really have to be careful that, you know, as I said, you're not saying things that can come back to hurt you later.
Okay, now, can you take inconsistent positions in the PTAB trial and district court litigation?
So, I mean, I think I personally would not, because I think it can hurt you. There are some instances to try to kind of sidestep the issue a little bit on claim construction. So one way of doing that is to sort of say that, you know, the PTAB doesn't really need to, for purposes of resolving, you know, the trial here, the PTAB doesn't need to go into claim construction. The parties don't need to construe the claims. That's kind of a nice way of trying to sidestep the issues if you have really good art, and you know, can sometimes be successful. But as I said earlier, just having an overall litigation strategy that incorporates what you're saying before the PTAB as well, and making sure that everyone who's kind of running both parts of the case are on the same page. That can be tricky sometimes, because there are situations where you have litigation counsel running that side of a case, and then, you know, PTAB counsel at a different firm. So, you know, you're trying to make sure everyone is aligned. Yeah, definitely presents an interesting situation that parties have to navigate.
So earlier you mentioned discovery in PTAB trials is fairly narrow. Let's compare the two. How broad is discovery in district court litigation? Roshan?
So district court litigation discovery is broad. The United States is in fact famous for that. Other countries are not so broad in their discovery requests, and it is sort of what creates a large amount of the cost and expense to district court litigation, and patent litigation is no different. So the standard is just that if it's relevant to any claim in the district court proceeding, and that it is tailored to that relevance. It doesn't have to even be narrowly tailored. So it's fairly broad, and as long as what they're seeking is not privileged and arguably relevant, you'll likely have to turn it over.
What about discovery of the PTAB trials, Jeremy?
Sure. As mentioned earlier, it is fairly narrow. I'll start with what's known as routine discovery, because it's by far and away the most common form of discovery you get at the PTAB. And it's really not much. It's you're going to get whatever evidence that the other side relies on, because they're going to cite it and they're going to file it and serve it with their papers. You're going to get to cross-examine any declarants that the other side uses. So they'll put in a declaration. You'll get to depose that declarant in cross-examination. And you'll also get any information in a party's possession that is inconsistent with the position that they're advancing in a given paper. They're supposed to provide that to you along with the paper. And in my experience, routine examination is pretty much it for your average proceeding. There are also, however, what are known as mandatory initial disclosures. And I'll admit, I've never actually used these, and I learned about them for today's webinar. So I'd be curious about the other panelists' experience. But basically, well, at the outset, the mandatory part is a little bit of a misnomer, because it's something that you agree with the other side to do. It's not just as a matter of right, or you can file a motion to seek it. And these mandatory initial disclosures, there's essentially two options. The first one is very similar to the district court's initial disclosures. And it's basically the names of individuals that are going to have discoverable information and the subjects of that information, where the disclosing party could use that information to support its claims or defenses, and also copies of all documents in the disclosing party's possession that it can use to support its claims or defenses. So that's option one. The second option is more interesting, and I think it targets subject matter that can be the subject of potential discovery at the PTAB, even beyond routine discovery, through something known as additional discovery, and that's when a party is going to rely on a non-published disclosure to try to cancel claims, like a prior public disclosure that wasn't published, which is something you could use in a post-grant review, a PGR, not an IPR. Then the party is going to identify persons who are aware of that public, non-published disclosure and documents relating to it. And the other thing you can get through the second option is if a party is relying on obviousness, that's fairly common, they're going to identify individuals and documents relating to evidence of secondary considerations of non-obviousness. And so with all of that said, if a trial is instituted, we've done the mandatory initial disclosures, they're filed with the board. Parties can take discovery of any information identified in the mandatory initial disclosures.
Okay. So Jeremy, earlier you mentioned depositions. How long do depositions last in the PTAB trials?
So they can last, and the panel can correct me if I'm wrong, I believe it's up to 7 hours. It's just like federal court. I'll say in my practice, they typically don't last that long, but it also depends on the declarant that's being deposed, because your cross-examination is going to be limited to the scope of their direct testimony, which is what they put in their paper declaration that they signed. And so if you have a relatively short declaration, such as one proving up a reference, it's probably pretty hard to have 7 hours of questions that fall within the scope of that document.
But what about other types of discoveries, Ilya?
Yeah, so there is additional discovery that parties can agree to, where you kind of go a little bit further in what's going to be the documents and the information that's going to be at issue. Without agreement, it's subject to motion practice. So you're basically submitting a motion for additional discovery and explaining the reasons why this discovery is necessary. This comes up a lot in the context of estoppel. So if a patent owner believes that perhaps a real party in interest or a privy of a previously estopped party is now filing an IPR on the same claims as of a patent, or is estopped by a district court estoppel, then a lot of times the patent owner will basically go through this additional discovery process to try to find, emails, documents, agreements that show that there is some privity or real party and interest relationship. There are different standards for requesting additional discovery, depending on the post-grant proceeding that is at play. So in a PGR, requester has to show good cause for discovery, whereas in an IPR, discovery has to be in the interest of justice. And there are situations where requests for specific documents with a showing of relevance and unsuccessful attempts can be more likely to be granted, as we say on the slide. So, and if we go to the next slide, that there are these standards, and this is what the factors that one would go through to analyze and explain why additional discovery is necessary. In my experience, when a party is requesting additional discovery, making sure that the requests aren't overly burdensome and are like tailored to what they're actually looking for can go a long way. I've been involved in various cases where some of the requests were, when you actually read what they're asking for, it would result in a party having to produce thousands of emails, all emails for a very long time period, which is totally unreasonable. So I think just going through these factors carefully, making realistic requests can go a long way, and sometimes it could even result in an agreement before the parties to produce information if without kind of going through the formal back and forth. So so that's kind of how the additional discovery process can work.
Now, Roshan, when does live testimony occur in a PTAB trial? I know we mentioned expert depositions, or are there any other instances?
Yes. So there can be depositions of anyone who has submitted a declaration in the case. So that could be expert witnesses. Sometimes there's fact witnesses. So for example, in a petition that involves a piece of prior art that is not a patent, you sometimes need a declaration from, let's say, the author of that document to explain how it was distributed. And sometimes librarians get used, and so they can be deposed. So that's another form of live testimony. So anyone that submits a declaration can be deposed, not just experts. And the other party has a right to depose them. And if you don't make them available for deposition, the declaration can be expunged from the record. And then finally, not often used, but still there, is the opportunity for the judges to live examine a witness at the oral hearing. Again, it's not often used, but sometimes there's been inventors that of the patent that come forth. So for in that context, what they're trying to determine is, for example, when did the inventor have the idea? Because sometimes you can, depending on the patent, you can predate the prior art, get around the prior art, even if the documents used to challenge the patent are earlier than the patent was filed. If the inventor actually invented the idea earlier, that's a way to get around prior art, even if it describes what's in the patent. And so those types of declarations can be submitted, but also the patent office has the ability to, at the oral hearing, take examination of live witnesses.
Now, has anyone here ever used that option?
I have not in my proceedings. The vast majority of everything I've ever worked on or heard of has been the typical deposition track.
Yeah, I see Ilya and Jeremy also shaking their heads. Yeah, that seems to be a standard practice. Live testimony in front of the board is indeed very rare. Now, if the litigation is not stayed, right, and you actually have concurrent proceedings, is it possible to use documents from a district court litigation in a PTAB trial and vice versa? Jeremy, let's throw that one over to you.
Sure. And so the short answer is yes. And I've been involved in cases where there was a lot of use of district court discovery at the PTAB on various issues, specifically on real party and interest or privy issues where you know, if you're related to a party sufficiently that they're a real party and interest or privy, depending on what they've done in the past, when they've been sued with the patent, et cetera, you can be precluded essentially from seeking a PTAB trial. And that kind of evidence, it's easier to get that kind of evidence, I think, at the district court, because as Roshan said, the discovery in the district court is very, very broad. I think it's anything that might lead to reasonably useful information or something like that. And so there was a lot of that evidence coming in to the PTAB. And then the other issue was secondary considerations of non-obviousness, right? So commercial success evidence, long felt unresolved need, et cetera. Now, with that said, that evidence can be very useful. You have to be cognizant of any protective order in the district court. And really, I think you just have to read it. And then the one that I'm thinking of, based on the example I was just describing, essentially said that you had to get permission from the other side before you tried to use any district court discovery in a parallel proceeding, like an IPR. And so we just had to follow that protective order before we use the information. But I've also seen protective orders that basically preclude the use of district court discovery in the at the PTAB. And so it's something you just have to be aware of. And you know, maybe if you want to use confidential information from the district court, you're also going to need to put a protective order in place at the PTAB. And sort of a related note, sometimes the protective order will have what's known as a prosecution bar. And so if you're the patent owner and you're going to be getting confidential information about, or so I guess you're the plaintiff, and you're going to be getting confidential information about the defendant's technology or their, accused product or whatever, oftentimes there's a prosecution bar put in place because the defendant doesn't want you taking that information and using it to build your patent portfolio or strengthen your patent portfolio. And so there'll be a prosecution bar in place that says, if you have access to my confidential information, you can't prosecute patents. Well, that can become relevant in the PTAB context because, as mentioned earlier, you do have an option to amend your claims. And so it's something to be aware of. And I've been in that situation too, where we did file motions to amend, and how we handled that was we had a entirely separate team do the motions to amend, and there was no communication between the district court team and then the team on the IPR doing the motion to amend. So wrapping all of that up, yes, you can use district court information, but you should be cognizant of the protective order, and sometimes that protective order is going to have a prosecution bar as well that you need to be aware of.
So what about discovery from previous litigations? And I think, Jeremy, you touched on it a little bit, but Ilya, why don't we explore it further? If there have been multiple district court litigation on the same patent or the same family of patents, can the discovery from those litigations be used in a PTAB trial?
Yeah, so I mean, kind of along similar lines, you have to just make sure there's no protective order that's restricting the use of that discovery and what the parameters of that protective order actually are. One thing that I've seen a lot in these type of instances is just information that is public, like public briefing, deposition transcripts, that are touching on how a patent owner in particular has interpreted the claims that are being asserted, and taking those positions and basically showing in your IPR petition as a defendant how, even in line with all of these statements that have previously been made, how our petition now is showing the unpatentability of the claims, even in view of those statements. So that's one way, kind of in that particular IPR context, that I've seen prior litigation materials used. But as Jeremy was saying, like for confidential information, obviously, like to the extent you kind of have access, I don't know how you, I guess if you weren't involved in that prior litigation, I'm not sure how you necessarily have access to it, but you just have to make sure that whatever you're doing with any discoverable or discovery information, it's not violating any protective order.
Right. Well, as a patent owner, you may have access to all of that information.
Yeah, as a patent owner, right? Yeah, a lot of my views are on the petitioner side, because that's generally the side I'm on. But you're right, in that context, yeah, like all of the protective order stuff would have to be abided by as a patent owner.
Yeah, I imagine in these scenarios, you may also want to have your claim constructions positions more or less the same throughout different district court litigations.
Yeah, I mean, that's a big aspect of what I've seen. I mean, basically taking those claim construction briefs that a party has submitted in prior litigations and showing, through all that briefing, that this is what they think the claims mean. And as we've shown in our petition, that's how we're rendering these claims unpatentable. So it goes a long way.
Now, previously we mentioned this term, protective order. Now, we can get protective orders in district court. Can we have something similar in a PTAB trials, Roshan?
Yes. So a protective order, as many know, is the mechanism by which confidential information in the context of a district court litigation can be exchanged without fear that someone that's against you will use it for purposes outside the litigation, confidential information. So the Patent Trial and Appeal Board also has protective orders. They're in fact governed by the same federal rules of evidence that district court proceedings are governed by. And the Patent Trial and Appeal Board has a document called the Trial Practice Guide that we've mentioned in previous webinars that explains some of the rules and further than the actual rules themselves. And as part of that trial practice guide, they have a default protective order that can be used by the parties. What's interesting to think about is if you're challenging a publicly available patent with publicly available prior art, by definition, what is confidential, right? So as it turns out, there's not a huge need for protective orders on some of the key issues. You know, what does a patent mean? What does a prior art teach? How would a person of skill in the art understand those things? What do these technical terms mean? But when there are issues, for example, real party and interest, both from the patent owner side and the petitioner side, and you start getting into the confidential nature of relationships that parties may have, for example, an indemnification agreement between a supplier and a customer, depending on who filed the IPR. Those are the situations in which you would actually need a protective order, as opposed to in district court, where many issues are at play at the same time, not just the infringement of the patent, which oftentimes involves the confidential information of the defendant on how their products work, but also damages theories, et cetera. Those damages theories aren't really anything related to the Patent Trial and Appeal Board proceedings, nor are infringement theories related to the Patent Trial and Appeal Board proceedings. So while protective orders are absolutely available in the Patent Trial and Appeal Board proceedings, they are much more limited in their scope and in their use, because the core questions are typically ones that don't involve confidential information.
What about settlement numbers? Would those be under the protective order in a PTAB trial?
Yes, so anything confidential, there's no limit in terms of the rules on what can be protected by confidential information or by a protective order, what kinds of confidential information. However, as we mentioned earlier, the rules of discovery at the PTAB are much much narrower, right? So, for example, in the Patent Trial and Appeal Board, you can settle proceedings, and so if there is a settlement, they require you to file a confidential version of the settlement agreement. So you need a protective order in place to keep that settlement agreement appropriately confidential. But it's typically not part of the Patent Trial and Appeal Board proceeding to, for example, seek discovery on previous settlements, right? It's not really the venue by which you get discovery to try to negotiate a number with the other side.
So, let's go back to the claim construction issues and how they overlap between district court proceedings and the PTAB trials. I know we touched that base on it a bit earlier, but let's explore it further. Are there instances when the claim construction can be different, or should it be the same? Jeremy?
So I guess starting with a little bit of history, at the beginning, the PTAB applied a different standard for claim construction than the district court in most cases. And it was the broadest reasonable interpretation. I believe that applied to the claims of any unexpired patent. And of course, at the district court, it's the Phillips claim construction standard. And when there was that sort of inconsistency between the district court and the PTAB, sometimes it would be used to justify reaching different conclusions on claim construction. But all of that, I mean, I think it's been at least a couple of years now, maybe more than that. That inconsistency has been resolved. And now the district court and the PTAB both apply the Phillips claim construction standard. And so with that said, any claim construction determinations made in the district court or at the ITC, I think they're going to be persuasive at the PTAB, and under the rules, the PTAB basically has to consider them. They don't have to adopt them. The PTAB is going to make up its own mind based on the record before it, but prior constructions from a district court ITC under the same standard, of course, they're going to be fairly persuasive. And so ideally, to answer your question, your claim construction positions would align between the district court and the PTAB. Now, having said that, I've been involved in cases where the district court reached a construction and it was before the PTAB, and the PTAB reached a polar opposite construction. I mean, they couldn't have been more opposite. So they're not necessarily going to follow it, but I think it's persuasive, and I think it behooves a party to have consistent positions, particularly when the standard is now the same between the two forums.
Now, earlier you mentioned ITC. Can you explain to our listeners what an ITC is and the claim construction standard that's used there?
Yeah, and actually, I would appreciate some help from panelists who maybe have some ITC experience, but overall, it's the International Trade Commission, and you can go to the International Trade Commission and get an exclusion order to prevent the import of products that infringe your patent, and I believe they apply the Phillips claim construction standard as well. Going out on a limb there just a little bit. I have not been involved in any ITC litigation.
Yeah, I haven't been either, but I know they're fast, and faster than the PTAB trials. And remind me, where is the district court litigation is typically stayed? Are the ITC proceedings stayed due to a PTAB trial?
Last I checked, I don't think the ITC is very willing to stay their investigations. And so I think it's pretty hard to get a stay of the ITC in view of a PTAB trial that gets instituted. But that's from research I did a while back. I don't know if that landscape has changed, but I don't see why it would.
All right, so going back to claim construction, right now, more or less, most of the time, you have the claim construction in district courts and then PTAB trials that is in sync. What about globally, where different countries have different claim construction standards? Can claim construction be used strategically? Let's throw that one to Ilyar, since he mentioned he does do some litigation.
Well, yeah, I mean, I think really it helps, it forces parties to make statements on the scope of the claims that can be used to help or hinder infringement analysis. So essentially, you know, you're being kept to the same standard. So, you know, you're going to be, when you're analyzing the claims, you're analyzing the prior art under that, you know, in view of that. You're going to be making statements and kind of kept to that standard as to you know, what those statements mean, what you're saying the claims mean, what you're saying the scope of the prior art is. So it kind of just maintains that consistency across the board. And I think it would kind of aid in like global litigation as well, because you're saying that you know, just to maintain that consistency between all the different proceedings. So I think, yeah, so having that overlap definitely maintains kind of the alignment between the two forms.
All right, so let's go back to estoppel. I know we touched on estoppel briefly. Roshan, when does estoppel come into play during the PTAB trial?
Yeah, so by statute, when a final written decision issues, estoppel has kicked in. And the scope of that estoppel is essentially that you cannot raise or assert the same invalidity defenses or defenses you could have raised in district court once the final written decision occurs. And the big caveat is that, for example, if you, there are different types of prior art. Two examples of which are prior arts that are based on documents. So that would be like publications of academic papers, magazine articles, as well as patent literature. And then there is something the patent attorneys like to refer to as system prior art. So these are actual physical products that existed in the world and that operate in the same way that's patented, but prior to the patent, it can be used to invalidate. In the patent office, before the PTAB, you can only bring the document-based prior art. So estoppel applies for district court only to, for example, document-based prior art. And even the scope of that can be argued. You know, if you reasonably could not have raised that document because it was a needle in the haystack and it took you months and months to find it, you have to be able to prove that in district court. But the estoppel provision would not, in some situations, prevent you from making that. But it starts at the final written decision.
Okay, so if I have an application that's running on my phone, right, that would count as system art, and I could use that application in a district court litigation.
Yeah, that's right. I mean, if, for example, though, there's been case law that indicates that, okay, if I have a document that describes that same system, a manual, for example, and then the PTAB adjudicates that no, that's not, you know, the features that were described in the manual are don't invalidate the claim, right? And then you say, okay, well, I'm not using the manual now, I'm using the product in district court, right? But it's the same features. You're not relying on some implementation detail that's in the product that wasn't in the manual. It's the same features. Estoppel has been applied to that situation, even though it wasn't, it was a product and not a document.
So it applies to the same type of system art. Or
Right. If all you're doing with the system art is basically taking the same features of a document that you use. Now, if, for example, you were using a patent application in the PTAB proceeding, but that patent application had no relation to the system prior art that you're using, other than there might be some overlap of features, it's highly unlikely a district court would exclude that system prior art in that example. But if it was a patent application covering that same product and basically describing the same features that are being used for the purposes of invalidity in district court, then there's a higher likelihood that it would be stopped, even though it is a system prior art and not a document-based prior art.
Okay. Well, let's talk about settlement. Can PTAB trials drive settlement, Jeremy?
Yeah, thanks. Absolutely. I think one of the ways that PTAB trials can drive settlement is the PTAB trial is instituted and you're the patent owner and you know the statistics, only 5% of patents are going to make it out of that PTAB trial unscathed. And a large proportion of them are going to have every claim that's challenged invalidated. And so this threatens your patent. It can threaten licensing revenue you may have based on that patent. And I think that certainly can encourage settlement. I think the other thing about a PTAB trial is once the petition is written, which is a lot of work for the petitioner, but once it's written and filed, really the workload shifts for the first, what is it? 6+ months to patent owner, because patent owner is going to have to file a preliminary response if they want to try to avoid institution. And then after institution, the next paper is patent owner's full response, which is their case in chief. And so I think shifting some of that workload can force patent owner to take positions that they may not have really wanted to take or wouldn't have taken by then in the district court, where maybe it's all plain and ordinary, meaning just trying to keep the case going, right? Maybe they're looking for some kind of favorable settlement. Well, I think the PTAB proceeding can sort of put the shoe on the other foot in that way, if that makes sense.
All right, Roshan, what's your experience with settlement? I mean, I know you mentioned earlier that unified patents, they aim to eliminate bad patents. Do you guys settle, or is it more up in the air?
Yeah, we do perform settlements, and as our website indicates, it's for a royalty-free license. And but the point is basically the same, that the parties, whether a unified patents is sort of a third-party challenger or a first-party challenger, meaning you're an actual district court litigation, as Jeremy mentioned, right? Like what parties are dealing with is the reality that there's a risk that their claims would either get invalidated, or, you know, if you're on the petitioner side and challenging a claim and you lose at the PTAB, you know that the settlement numbers from the patent owner, to the extent they're willing to settle, are just going to go higher, right? Because now, in some patent owners' view, the patent has been gold plated, right, by the PTAB. It survived a challenge. There's estoppel. You lose defenses in district court that you could have otherwise raised, as we talked about earlier. So it is a lever by which people can use to settle. We actually did some statistical analysis, and it actually turns out that parties tend to wait through PTAB proceedings because you kind of get an initial take by the judges and then a final written decision. So settlements are not necessarily driven by PTAB proceedings, but they help sort of the conversations moving forward because there are more decision points being made faster than in district court litigation.
Right. So if I want to settle a PTAB trial, what is the process? Can I settle at any time, or should I settle earlier than later? Jeremy?
Yeah, I mean, you can seek to settle at any time. As shown on the slide, if you settle and then you request the PTAB trial be terminated and you're very late in the PTAB trial, the PTAB doesn't have to grant the request to terminate the trial due to the settlement. They can go ahead and proceed to final written decision. And I've seen cases where they've done that. I was involved in a case, though, where we argued the oral hearing, and it was a couple of weeks before the final written decision, and the case settled, and we moved to terminate, and they still granted that. So, you know, it just is, it's going to be panel dependent, but if you do it really late, they can decide to go ahead and go forward and issue the final written decision using the logic that they've already done all the work, right? I mean, so much of the work is done. Let's just wrap up the trial. We're not going to terminate it. But with that said, I think your chances of avoiding that kind of outcome, if you do want to terminate due to settlement, it's better to move to do so earlier in the trial rather than later in the trial.
Yes, I think the takeaway here is that you can request the settlement, but the settlements are not automatic.
Right.
So earlier also mentioned that you can make, patent owner can make amendments to the claims during the PTAB trial. What is the proceeding for that, and should it really be used? I'll throw that one to you, Jeremy, again.
Sure. So you can, if you're a patent owner, seek to amend your claims during a PTAB proceeding. The time to do that would be with your patent owner response or in place of your patent owner response. So 3 months after institution, you can move to amend your claims. And essentially what you do is you propose substitutes to the claims that are at issue in the trial. Usually it's just you get to propose up to 1 substitute claim for each claim that's at issue in the trial. Your amendments have to be responsive to grounds of patentability raised in the PTAB proceeding. You have to affirmatively establish written description support for any of those features, and amongst other requirements. So there's actually kind of a litany of requirements on patent owner to try to amend your claims. And once the motion to amend is filed, the other side, petitioner, is going to have the opportunity to, of course, oppose your motion to amend. And they can do that based on any ground of unpatentability, which is, I think, a really important thing to know, right? Because in an inter partes review, for example, you're limited to invalidating the issued claims based on 102, 103 using printed publications or patents. Once you move to amend your claims as patent owner, those proposed substitute claims are really amended claims. They're open to 101 challenges, 112 challenges, not just 102 and 103. And so petitioner sort of has the whole toolbox available in this opposition. They're going to have, of course, expert testimony typically. And after that, there's a pilot program. I think it's still considered a pilot program. But anyway, what you can do as patent owner is you can request preliminary guidance from the PTAB. And so the PTAB is going to look at your motion to amend, it's going to look at the opposition, and it's going to give you an indication of whether they think your motion to amend is going to be successful or not. And that's pretty powerful should you choose to do the motion to amend process. I mean, getting feedback from the board at that earlier phase in the proceeding is really valuable. And another thing that they've now allowed patent owners to do is to file a revised motion to amend. So after receiving the opposition, after receiving the PTAB's preliminary guidance, you can file as patent owner an entirely new motion to amend. You can change your proposed substitute claims. Typically, you want to try to address any deficiencies that petitioner pointed out in the opposition, or maybe the PTAB did in the preliminary guidance. And if you do that, then petitioner is going to get to oppose your revised motion to amend. So as you can see, it's like a mini IPR within an IPR. I think it's fairly expensive. It's time consuming, but that's sort of the process. And ultimately, the PTAB decides in the final written decision whether your proposed substitute claims are patentable or not. Now, whether it makes sense to go through this process as patent owner, I err on the side of no. I mean, every situation is different, but it is a very adversarial process that you're using to try to get your claims amended. Whereas if you went to an ex parte reexamination, for example, it would be you working with the patent office, similar to traditional prosecution without petitioner's involvement. At the PTAB, you have opposing counsel who's of course patent savvy and has an expert, and they have resources, and they're going to be collecting evidence, and there's going to be testimony against your claims. It's very adversarial. I think the chances of success are fairly low. And so in general, I would err on the side of not trying to do the motion to amend process if you're a patent owner.
All right, but in the event that you do and you succeed, is there any estoppel that attaches to those claims, Ilya?
So in relation to estoppel, it's kind of an issue that's up in the air. Like pro estoppel, there's an argument that petitioners could have opposed the motion to amend. They could have explained, why the motion to amend was improper, introduced prior art, and also introduced all the other reasons on the other grounds like 112, 101 as to why the amended claims are unpatentable. So the petitioner did have a chance to address the amended claims. So there should be estoppel that applies after assuming those claims issue. But then on the other hand, against an argument that estoppel would apply, this is, as I think Jeremy just mentioned to it, it's like a little mini trial within a trial. So is that truly a full and fair opportunity for a petitioner to, address these new or the amendments to the claims, conduct a fulsome prior art search, which sometimes that can take a while. It can take a few weeks to get really high quality results, going back and forth with a searcher, trying to really refine the results and target, what you're actually looking for and what the claims say. In that type of a scenario, it's really not enough time and enough of an opportunity for a petitioner to put forward, their arguments and their fulsome reasons as to why the amended claims are unpatentable. So issues up in the air. There are arguments on both sides, but we'll see how that kind of plays out and if that's going to be addressed in any later decisions.
But what about alternative venues, Roshan? Are there any other alternative venues that you can use to amend the claims of a patent?
Yes, so the Patent Office allows for at least two procedures in which you can amend claims. One called ex parte reexamination and another called reissue. There are some, with respect to reissue, there are some restrictions on that are probably beyond the scope of today's conversation, but it does allow for example, clarifications of grammatical errors or wording errors. Reexamination allows for a more fulsome, less restricted opportunity to amend the claims. And in that context, you, as the patent owner, can submit a request that the Patent Office re-examine your claims and actually provide prior art. So it's like you're killing your own claims. You're trying to challenge your own patent, but you have the goal in mind of submitting amendments that you know are going to get past the initial prior art you're providing that show that the claims may not be valid. The challenge, though, the risk with reexamination is that now you have an examiner involved, and an examiner will look at those amendments substantively, and the examiner may do their own prior art search to continue to try to invalidate those claims. But the amendment rates in ex parte reexamination are much higher than at the PTAB. And so if you're a patent owner looking to amend your claims, that is one of the best places to go, even though it does carry some risk with it. And the final risk for across all of these opportunities for amendments with patents is that you lose some opportunity to recover damages. So as a reminder, when you file a patent litigation lawsuit, in general, typically, you are allowed to recover from a district court proceeding 6 years going backwards from the day you filed your patent lawsuit, the damages of that time period plus the time period moving forward. If you choose to amend your patent using the ex parte reexamination process, for example, or the patent trial and appeal board proceedings we've been discussing, you lose that 6 years of back damages, right? So you can only get damages moving forward from the date that your amendment's issued.
So remind me again, Roshan, and I'm not sure if you mentioned it, in a re-exam, are you limited by the number of new claims that you can add?
Yeah, so in a re-exam, you can add new claims, but they have to be sort of related and narrow to the claims that were originally challenged. You can also add new claims. You're not really limited. There might be some extra costs on it, but they have to be kind of related to the initial subject matter.
Okay. Whereas opposed in the PTAB proceedings, it's usually a one-to-one substitution.
That's right. That's right.
Okay. So suppose you have successfully amended the claims. What happens to the original patent, Jeremy?
So if you successfully amend the claims, the original patent doesn't go away. What happens is the PTAB is going to ultimately issue a trial certificate, and they're going to basically put the substitute claims that were found to be patentable in place of the claims that are being substituted to the extent they were found unpatentable. So basically the trial certificate is going to make all the changes that were requested in the motion to amend if successful, and any claims that didn't survive are going to be canceled. But that all happens in a trial certificate. It stays the same patent, which we were talking earlier about reexaminations and reissues. That's one interesting thing about the reissue is you actually have to give up, you have to surrender your patent, and then if you're successful in the reissue, you get a new patent, sort of unique to reissues. And ex parte reexaminations and through the motion to amend process at the PTAB, you keep your same patent, it just gets changed. The claims get changed.
That's actually a good point. So for the reissue, if your patent is in litigation and you're filing a reissue and surrendering your patent, does the litigation go away?
I actually don't know. I don't know why the district court wouldn't allow you, if it's the right time and the right circumstances, to amend your complaint to assert the reissued patent. The one thing I will say that I think is really interesting is with the 1-year bar implications. And so if you're a patent owner and you've sued someone with your patent, the 1-year bar starts going. If you do a reissue to amend it or fix some issue with it, that's a new patent. And so the 1-year bar is not relevant to that patent. And petitioner, even after having been served with a complaint of the original patent you surrendered, even 1 year after that, could then IPR your reissued patent, where that's not the case if you're a patent owner and you've used a reexamination, right? So you sue someone with a patent, you bring it into reexamination, you amend your claims, 1 year goes by since you sued them. Well, the reexamined patent is the same patent. They've already been served with a complaint alleging infringement of it. They're not going to be able to IPR your reexamined patent. So I've always thought that was really interesting.
Well, what about this new patent that the patent office issues? Can the patent owner sue on the new claims in the current or future litigation? Ilyar?
Yeah, so I think Jeremy kind of touched on it. I mean, I think assuming you're in the the period where you can still amend your complaint, you know, I don't think there would be an issue. Having said that, though, it depends what new claims you're adding, because Roshan touched on it. When you're amending claims, if they are like substantive amendments that are changing scope, then intervening rights is going to kick in, and your damages period is going to be totally reset. Intervening rights comes in a couple different flavors. There's absolute and equitable. Absolute means that they're intervening rights extending to anything that was made, purchased, sold, used before the grant of reissue, or the grant of reissue, or the new claims, the certificate issues for the new amended claims. But there's also equitable intervening rights, and that can actually extend for the period, a certain time frame past when your certificate for the new claims issue. So really, like when you're changing claims around through the motion to amend practice, that can really impact the damages period in litigation. So there's a question as to, you know, whether it would be worthwhile to even, you know, add them into a current litigation, or but you know, that's just one of the considerations you have to make, and something that a party would have to decide.
We're almost out of time, and we're done with our 3-part series. Before we go, let's ask our panelists to give one tip to the petitioner and one tip to the patent owner when they're in the PTAB trial or considering the PTAB trial. So let's start with Roshan, then go to Ilya, and end with Jeremy.
Yeah, so for petitioner, I feel like the biggest tip I would provide as the side that I am have almost always been on is carefully simplifying the issues. So the more you can do to simplify, I think as a petitioner, you're thinking, okay, I've got this estoppel, and I'm a little bit concerned about not having some arguments. Let me put all my arguments out there. And at times that can overwhelm the PTAB judges. They're very technically savvy, but again, they're also under time limits. And so if you force them to look at too many issues and you don't simplify things, you are going to run into the situation where you may not get a judgment you like, and then now you're stopped because you made too many arguments from a practical standpoint. So really understanding that is going to be very helpful. And then on the patent owner side, I think one of the things that we've seen that's been quite effective from the patent owner side is understanding the strategic positions you can take as the proceeding progresses. So for example, you may want to try certain arguments in your preliminary response and then save some arguments for your patent owner response, and then not try to make all of the potential arguments you can make in your patent owner response you're supposed to, but you do get a surreply. And so you can try to cleverly weave some arguments in your surreply since you get the last written word. And then you also have oral arguments. And oftentimes I see patent owners just kind of repeating what they've already said in the written briefs at oral argument. And in some ways that is what you're supposed to do because you're not supposed to try to make new arguments. But I think understanding that at each stage of the process, you actually get more times to speak to the patent office, both in written word and in spoken word, than the petitioner does. And so carefully thinking about how you can leverage those advantages for yourself is where I think patent owners have a lot of opportunities to gain a strategic advantage on a playing field that most patent owners feel like is tilted against them.
All right, let's go over to Ilya.
Sure. So on the petitioner side, I totally agree with what Roshan was saying. I would say just clarity of thought and organization can really go a long way. I think when you're streamlining the ideas and kind of making your petition as focused as it can be, having those major themes woven into the arguments, but also just when you're explaining, making sure that your explanations are, you know, clear, technically accurate, put in such a way that someone can pick it up and understand, you know, what you're actually arguing, even though it's like a very, you know, could be very technically dense, but just put in a way that that a PTAB judge can clearly just see what you're saying and then hopefully understand that your position is extremely reasonable. That's something that is, I think, very effective and does go a long way. On the patent owner side, I would also say that just making reasonable arguments that aren't completely off the wall actually can be really, and kind of steps through all of those other aspects, like is clear, concise, technically accurate. Like that goes a long way, because I've seen in some patent owner documents, I feel like there's already somewhat of a skew before the PTAB. There's kind of a reputation, parties are bringing plaintiffs to the PTAB to kill their patents, and there might be some of that narrative, maybe unconsciously woven into certain PTAB judges. So when patent owners respond to petitions with arguments that, just might not be the most reasonable argument to make, maybe they're not as selective as they should be, I think that can kind of discredit their overall papers. So just making the arguments that are reasonable as a patent owner can go a long way and show that, you're a sensible party here. You're trying to assert your patent right. This petitioner is making all these arguments as to why the patent is not valid, and here is like a cogent analysis of why they're not correct. I think that can go a long way.
All right, and Jeremy?
Sure, I think it's going to echo a lot of what we heard, but for petitioner, my tip would be to spend the time and effort that you need to on the petition, right? So budget enough, do very thorough prior art searching, because it really is in a PTAB proceeding, you're one shot. And if there are issues in the petition, and I've been involved in cases where issues have come up, it can be extraordinarily difficult to shore up deficiencies in the petition later on in the trial, and it'll kick off all kinds of little disputes. So do the work on the front end to make sure your petition is like was said, is clear, but also you've got all of your evidence, you've got great prior art, you've really vetted it, because once you file the petition, your chances of changing your tune are pretty slim. And then for patent owner, I don't work on the patent owner side too much, but I would say really take advantage of the patent owner preliminary response, and specifically it's your ability to argue for discretionary denial. There are a set of arguments that really only make sense pre-institution, right? It's you shouldn't institute this because the petition has too many challenges. It's going to be a waste of time to consider all of them, or the district court litigation is too far along, or there's some relationship with another party that render it inappropriate to institute. And so as patent owner, I would really assess those reasons that a petition, even otherwise meritorious, can be discretionarily denied, and make those arguments at the one time you really have the opportunity to, which is in that patent owner preliminary response.
Well, that concludes our 3-part webinar series. Big thank you to our panelists, Roshan, Eliar, and Jeremy. And if you're considering a PTAB trial or need a defense, feel free to contact any one of us. Thank you.